I'm going to talk about general principles of valuation and how valuation and the law relate to one another. Once I've done that, Aaron's going to move on to look at some specific issues which arise in respect of the 1954 Act in particular. We're going to look at the case law. We're going to look at some of the valuation issues which crop up, and we're going to look at some of the solutions which we think might be relevant. And to wrap up, I'm going to talk about valuation in some other context, business rates and in particular. The number of circumstances in which valuation arises as an issue in a legal context are manifold. Some of the main ones are on screen there. Where we're dealing with rental income, the three key valuation places which come up to focus on today are lease renewals under the Landlord and Tenant Act 1954, rent review clauses within leases, and your assessment for non-domestic rating, the amount of business rates you're going to pay. Things like council tax and compulsory purchase valuation tend to be concerned with capital value rather than rental value. And as a general proposition, we suspect something which is a big short-term shock, like the COVID-19 situation, is going to be more relevant to rental valuation than capital, which is why we're going to focus on that. Now, valuation is a strange subject in some respects because it draws on a whole host of disciplines and involves elements of all kinds of different things which in producing an answer. There are clearly elements of law involved, otherwise people like Aaron and me wouldn't have much to do with it. But there are also a lot of science and arithmetic and mathematics wrapped up in valuation. And critically, there's an awful lot of judgment. The judgment of an expert valuer, the opinion evidence of the expert, is often the thing which speaks valuation, such as science in valuation. As to what law does specifically, the key function of law and lawyers in valuation disputes is in setting the framework within which the values have to work. It's all about identifying the sort of questions that the valuers have to answer, the type of assumptions they have to make, and the kind of thing which they're valuing. Now, the first step you have to take in evaluation is to identify the characteristics of that framework, because you have to know who the tenant is, what the term is, what the other covenants in the lease are going to be, all those kinds of considerations. And those are questions which the law gives you the answer to in this context. It's important, though, to understand that there are limits to the role of the law here. And one of those key limits is that case law is generally not of much assistance once you have set the framework. The best quote I can find to support this comes from it's a business rates case actually called York Museums. I've put it on screen. I won't trouble you by reading it out. You can all see it there. But in effect, once you have created your framework, once you've identified the questions for the valuer to answer, there's not much of a role for precedent at that point. And a fairly common difficulty that I encounter in the valuation cases I do is that people try to rely on previous decisions, not just to establish the framework, but to establish what the actual valuation answer ought to be. And that is an approach which is often fairly fruitless. You're better off leaving the case law to one side once you've worked out the nature of the hypothesis that you're trying to value on. Once you have established the framework and you move on to the valuation exercise, there are a whole host of ways in which valuation can be done. There's a whole series of different methodologies that valuers adopt. Which method is going to be most suitable, or which methods, I should say, because you're not limited to one method, is a question for valuers rather than for lawyers. but it is obviously informed by the framework within which the valuation is taking place. An obvious example, I was in the High Court last month on a rent review case where the rent review tied the increased rent to the RPI. It was an index-linked rent. So evidence about market transactions of similar properties would have been completely irrelevant there. If you're dealing, as you usually will be, with open market valuation, what the property's worth on the open market, then the place which you will usually start, the place which valuers will normally go to in the first instance, is what we call the comparables method of valuation. Now, I can't do any better than Mr. Justice Forbes in explaining what comparables valuation actually involves. There's a quote on screen there which I commend to all of you as a really lucid explanation of what this entails. In essence, you're finding actual evidence from the real market of real lettings on other properties and working out how your property differs from those. By getting together a big basket of comparables in that way, you can move towards finding the valuation answer for your particular property. Now, usually if you're dealing with comparables, you're going to be looking at transactions. An open market transaction on a similar property from a similar time is going to be what we would call the best evidence. But it's not the only evidence. There are a whole host of other things that can support a comparables valuation as well. Asking prices, for instance, can be an indicator of the upper end of value. Similarly, things like indices, general market movements can all help. There's a series of guidance papers produced by the RICS on valuation, and the 4 on screen are the key ones listed for comparables valuation in the guidance from the end of last year. Sometimes you get properties which simply can't be valued on the comparables basis. That can be for a number of reasons. The type of property may be one where it's simply not ever let in the market. I did a case last year about a quarry and a cement works in the northeast of England, and no one ever lets quarries. It's not how they are transacted, so there's no market evidence of what they're worth. This is a bigger issue in things like compulsory purchase and business rates, where property has to be valued whatever its type is. If you're dealing with a 54 Act renewal case, then by definition, you're concerned with the type of property which is capable of and is let. But nevertheless, sometimes you will encounter properties, rarely if ever let, in which case there may not be comparables. You may have a pool of comparable transactions, but you may lack the data you need to be able to analyse them properly. It's no good knowing what the headline rent is on a lease if you don't know whether or not there was any rent-free period, for instance, or you don't know whether or not, you don't know what the term is, say, which these are issues which can sometimes arise, and that lack of data greatly reduces the value you can attach to the transaction for obvious reasons. Similarly, you may have perfect information on all your comparables. You simply don't have a coherent picture. It doesn't give you any sort of pattern from which you can derive evidence for your case. There are certain classes of property where the headline rents are almost always different on new transactions from the kind of things that occur on ongoing transactions in a lease renewal scenario. So think of the first letting of an anchor unit within a department store, say. The bargaining position of the tenant, by virtue of being the first one in, is so strong that it can distort the market from what it would otherwise be. And that can cause an incoherent picture to emerge from the comparables you have. If that's the situation, there are a whole host of other things that valuers can do to enable them to get to the right answer on what the property is worth. I've given 4 of the more common there. Very briefly, receipts and expenditure valuation works on the premise that the tenant's never going to pay more in rent than they would pay out of the net receipts of the premises once they've taken a share for themselves. So you work out gross receipts, you work out expenditure, that gives you net receipts. You calculate what the tenant's going to take from that to make the business worth running, and what's left represents your rent. The contractor's basis works on a similar way. It is premised on the proposition that the tenant's not going to pay more in rent than they would pay annually in order to acquire land and build an equivalent property on that land. So you get a quantity surveyor to tell you the build cost of the building, you work out the land value and add them together to get the capital cost of the thing, decapitalise it, and what's left will be the amount you'd have to spend in interest on servicing loans and so on if you were to build it yourself. That can be a proxy for rent if there's no better evidence. That's the sort of method you commonly use on things like factories, with no special characteristic, but not a lot of letting evidence. You can also use the contractor's basis for bits of valuations within wider properties. The air conditioning in shops, for instance, is often added after all of the market transactions have been carried out. If you have to value the air conditioning, then include it in the valuation, which you have to do in business rates, for instance. Then you'll often use the contractor's basis to value that bit and then add it on to the comparables valuation of the rest of the property. Finally, you get other quite rare and unusual methods like the shortened method, which is used for things like bingo halls, and sometimes what we call tone valuation, which is where you've got a general sense of what other things are worth in the market in other contexts, from which you can extrapolate a sense of what the rent is going to be worth for your property. So with that introduction to valuation done, I'm going to hand you over to Aaron now, who's going to talk specifically about how the COVID-19 pandemic pans out in this valuation context. Thanks, Aaron.
Thank you very much for that introduction, Luke. That's very helpful. The best way, I think, to illustrate the current problem is to look at an example. So here are some hypothetical parameters for an example that I've set. So let's suppose we're acting for a landlord of a premises in London, which was previously held on a 10-year lease and traded successfully as a restaurant. The tenant's lease was coming to an end, so in late 2019, proceedings were commenced for a new lease under the provisions of the 1954 Act. Both parties' agents were able to negotiate all the terms of the new tenancy, except for the rent. The premises, which we'll say is 3,000 square feet in size, was previously yielding a rent of £75,000 per annum. The new term that the parties have agreed is for 5 years. And the landlord is confident that they could obtain a fairly hefty increase in rent, given the prevailing market conditions at the end of 2019. So, as Luke has alluded to, in a usual case, each side would have an expert report prepared, and each expert would set out their view of the rent based on their basket of comparable market evidence. They'd be looking at the agreed or determined passing rent for recent and local transactions for properties of a similar size used for a similar purpose. Sometimes the agreed or determined rent on a rent review for a property of a similar size used for a similar purpose. Those figures would then be slightly adjusted to recognise any idiosyncrasies of the subject property and used to determine the proper price per square foot of local restaurant properties at the current time. Obviously, given the current situation, it is fairly straightforward to see what problems there might be if this method were to be attempted at the moment. The first and perhaps most obvious problem is that there has been a virtual cessation of the market since late February, early March, and thus there are in fact no current transactions at all with which to populate the basket of comparables. Secondly, given the changes to the way restaurants can operate at the moment, there is not a huge demand from potential tenants to sign a new lease of a restaurant, and therefore the demand for leases of restaurants has reduced significantly. Thirdly, many tenants in the hospitality sector are seeking rent deferments or rebates because of the disruption in trade and profit. So looking at the actual agreed terms of the lease or the agreed terms of any transaction in relation to rent may not actually give an accurate picture of the actual state of the market. Fourth issue is that any transactions that do take place at the moment may well be motivated by factors that are not the norm. So insolvency considerations, business consolidation, matters that have in effect forced a transaction to take place rather than being an ordinary market transaction. In the course of normal events, these transactions would be identified as outliers within the mean average of what rents are being paid for a certain type of premises in a certain area. But when there's so few transactions and those transactions are yielding figures, those figures may actually give a misleading impression because of the reason that they are entered into. One thing that does appear clear is that pre-pandemic evidence and post-pandemic evidence could give wildly different valuations for a property when taken just a few months apart. If the current trend of the market starting to recover does continue, there may well be a situation in fairly short-term order where the market's back to how it was pre-pandemic. We don't know yet, but the point is what you will have is an almost artificial blip throughout most of 2020 where there is either no evidence or the evidence is distorted, or there is evidence that people aren't entering into transactions. So with that considered, with those current problems considered, the first thing to actually address is the date of the valuation, because obviously that is crucial. If the valuation is deemed to take place right at the low ebb of the pandemic, then that can cause specific and different problems. So what is the appropriate date to value property? In the two situations that I'm concentrating on, there are slight differences. So in the context of a rent review, the valuation date is a specific exact date fixed by the instrument that gives rise to the review. So it's an exact point in time and could, in all likelihood, there are examples of this happening. There was a rent review on the 1st of June 2020. Now, in the context of a new lease under the 1954 Act, the date of valuation is the date of the new lease. By section 64 of the 1954 Act, that is a date 3 months from the trial. Now, given there is a possibility of an appeal against any order made after a trial, the deemed date of the new lease is always seen as being 3 months and 21 days, that 21 days being your appeal period, from the date of the trial. So to contrast, we have rent review where there is a strict 1 day in time, and new leases where the valuation date is a strict date in time, but it's after the trial. So those are the two main differences between those two. It may well be beneficial, depending on who you are acting for, landlord or tenant, to see if there is any wiggle room and whether there is any leeway to this strict approach. Again, the position differs when whether you're discussing rent reviews or whether you're discussing new rent under a new lease. In the case of rent reviews, in reality, the determination usually takes place sometime after the valuation date, where the market may have changed, and in the current climate, more evidence may be available. That's because obviously the valuation date is usually the review date, and the parties don't consider exercising that until after it has passed. There is some difficulty with the case law and seeing what it says with regard to the question of whether or not any evidence can be considered after the fixed valuation date. In the first case on screen there, Sagama and Penny Leroy, Staunton J made it clear that if a comparable transaction after the review date can reasonably be said to be probative of the state of the market at the review date, then it should be admitted in evidence. In other words, if there was strong and clear evidence that appeared after the review date, that can still be considered if it is probative of the state of the market at the relevant date. This statement has been accepted as correct by the editors of Hill and Redman on Landlord and Tenant, and in another first instance decision called Curry Group PLC and Martin, which is also on the screen. But those are both first instance decisions. There has been no consideration of this point about considering evidence after the valuation date by the higher or appellate courts. Indeed, there is some academic criticism of the conclusions reached by Mr. Justice Staunton in Sagama. Firstly, he gave no real justification for his conclusions. Secondly, he was not referred to several prominent authorities. And when one considers the logic for limiting the evidence to that is available before the valuation date only, there is quite logically compelling reasons for limiting that valuation. The reasons were neatly set out in the case of Gaze and Holden. I won't read out that entire quotation, but in summary, when you think about it, this is quite clear. In summary, the exercise that the valuer is attempting to undertake is to ascertain what a willing purchaser would pay at a certain date. That purchaser could not, of course, have knowledge of what would happen after that date, and therefore to allow a valuer to value with additional knowledge that the contracting party would not have had would seem to give an unnecessarily artificial tone to the valuation exercise. So my view is that any attempt to include later comparables, i.e. comparables that were of transactions that were executed after the valuation date in a rent review case, isn't necessarily going to succeed because there appears to be some logic in keeping the evidence fixed to that known on the valuation date, but there are some authorities that say you can do that, and therefore I do expect this to be an area there is some considerable legal debate on, and some cases coming out in the future. The position with the 1954 Act is, of course, slightly more, allows slightly more wiggle room. The exercise the court is undertaking in a 54 Act valuation is not fixed in time at the trial, although the valuation date is not that far in the future. There is a case called Lovely and Orchard Services Limited, where the court held that that evidence that indicates changes may need to be taken into account of between the date of the hearing and the date of the start of the new lease should be considered. So if there is any evidence that the market is actively changing and will be changing in the next 3 to 4 months, then I fully suspect that evidence will both be admissible and indeed relied on by valuers and surveyors. Of course, whichever party is seeking to rely on future evidence will have to ensure that it is presented clearly and forcefully and focuses on changes that are likely to occur in the very short term. Once we've established that there's a very limited window for the time that the valuation must be conducted, we now go on to consider what other issues arise and what case law says should be done about those. The first issue is, as it says on the screen, supposing your valuation date is today, what should be done about the lack of transactions? Is this evidence of a lack of willing lessee and lessor? And how should that be dealt with in the valuation? The first point to note is Section 34 of the 1954 Act only talks about a willing lessee, a lessor, I beg your pardon. However, Dennis and Robinson made it clear that there needs to be a willing lessee as well, because if there wasn't, then how could you consider an open market letting? So although the Act actually only speaks in terms of a willing lessor, it's been deemed axiomatic that there must be a willing lessee as well. So what characteristics are attributed to these willing lessees? In the case of F.R. Evans, the court set out the characteristics that should be assumed of those willing lessee and willing lessor. After all, and it does pay to just take a step back here, we mustn't lose sight of the fact that what we're trying to do is undertake a hypothetical exercise to find an answer to a statutory valuation. We're not actually giving the valuation, we're simply answering a question so that the court can undertake its function, which is to determine the rent in such circumstances. Now, it's worth just setting out what these are. Of note is that the landlord is not afflicted by personal ills such as cash flow crisis or inopportune mortgagees, nor being someone to whom it was largely a matter of indifference whether they let at that time or wait for the market to improve. Similarly, the tenant was a hypothetical person, not being nor necessarily having any of the characteristics of the defendant tenants, actively seeking premises to fulfill the needs which the demised premises could fulfill, taking account of similar factors to those taking account by the willing lessor, but again unaffected by any of the liquidity problems, governmental or other pressures to boost or maintain employment in the area, and so on. It does appear that the hypothetical landlord and tenant are quite robust contracting parties. The next thing to consider is what about the fact that the premises might not actually be open currently? In the case I've put on screen there, Northern Electric and Addison, it was held that the narrowness of a user covenant was something to consider when valuing rent. Now, the reason that that is relevant is because you have to consider what it is that prevents a property currently being occupied or utilised. In our hypothetical, there is a restaurant. For the last 3 months, there has been a statutory bar on restaurants opening and serving food inside. So the thing that has stopped the restaurant being able to be utilised is a mix of the law and the user covenant. So if we have a situation where user covenants and restrictions ought to be considered when calculating the value of the rent, then there's a strong argument that if there is a current restriction on using the premises pursuant to the user covenant, then that also ought to affect the rent when it's being valued. So that then may well become one of the idiosyncrasies that has to be taken into account when the basket of comparables is looked at. There is an argument under section 34. The test under section 34 requires assuming only that a hypothetical tenant is willing to take a lease, not necessarily that the lease will have any value to that hypothetical tenant. Therefore, the argument goes, if there's no demand in the open market for a lease, the value of that lease is only nominal. Now, I've actually succeeded in arguing this point before the pandemic took hold, but that was in some very unusual circumstances. My own personal view, nominal value argument can be reconciled with the characteristics that we're obliged to give to our hypothetical parties. We have to remember that liquidity problems and government pressure are not a factor that the willing tenant should have attributed to it. The willing tenant is actively seeking premises to fulfill needs which this premises could fulfill. On that basis, my personal view
Well, it seems that we've lost Aaron. I'm not sure what's happened to him. I don't know if anyone can hear me. I hope you can. What I suggest we do is that while we wait for Aaron to come back, I'll talk a little bit about what we were going to conclude on, which is the law of business rates and how all of that fits together with what's going on here. As an interesting segue into that, before I move on with the slides, the IRC and Gray case and the whole notion of nominal valuation where no demand exists was actually canvassed by the Supreme Court last year in the specific and quite different context of business rates. That was a case where you had a property which was one of about 7 large government type buildings in the north. The situation was that at the valuation date, all of them but for the premises in question had an occupier in place, and there was no one else in the market who'd be interested in one of these buildings. So that in the real world, the valuation of the property would probably have been nominal. There was simply no one who wanted it. However, as Aaron's indicated, the same thing happened in business rates as Aaron's talked about for 54 Act and rent review valuations, which is that aspect of market type obsolescence couldn't be imputed to the hypothetical parties to the valuation in order for a property to get a nominal valuation in business rates. And I'd suggest similarly in the contexts that Aaron was looking at, you need something more. What you need is that the property is completely obsolete as a matter of either its structure or its function. So if it's a kind of property that's built making floppy disks, say, no one buys them anymore and it can't be converted, it's not simply a question of the particular availability of particular tenants on the valuation date. It's that the whole concept of the property has become obsolete. So there's the case, if anyone's interested, was called Tellurial Trillium, which was, as I say, an interesting business rates case on this topic. In terms then of business rates valuations more generally, one of the real challenges which occurs in business rates is that the valuation date is not necessarily the same date as the date on which you assess the physical characteristics of the property. You have 2 dates in play. They're generally called the valuation date and the material day. what happens is that the statute prescribes a series of factors which are taken at the material day. Everything else is taken at the valuation date. Material day factors are things like the physical state of the property, matters affecting the physical enjoyment of the property, which would include things like a legal prohibition on occupation, and things like the mode or category of occupation which the actual occupier puts the property to. And what you have to do is this rather difficult and artificial exercise of picking up the physical state of the property from one date and working out what that property would have let for if you took it back in time to the valuation date. Now, this is highly relevant in the present context because where there is a change in one of those material day factors, where a matter affecting the physical enjoyment, say, of the property arises, then that can trigger a business rates revaluation. The valuation date for business rates at the moment is the 1st of April 2015, when not only had the current pandemic not begun, but I think none of us in our wildest dreams would have imagined such a thing might have occurred. And yet, where you've got the regulations around the pandemic arising and introducing restrictions on property use now, you have to try to imagine the impact that they would have had back in the market in 2015 had they existed at that time. And this is going to throw up all kinds of really very difficult questions for valuers. I think some of the intellectual contortions that are going to have to be gone through in the business rates field to make sense of all of this are going to be quite dramatic. My suspicion is that for a lot of properties, there's going to be very significant reductions in the amount of business rates they pay, because business rates is based on rent, and how much would you as the hypothetical tenant pay for a property which you can't use if that property is, say, a theme park, the use of which is dependent on people going to it, and the government's legislated to say people can't leave their homes. You know, in that sort of situation, the value may well end up being nominal. As I said, there are going to be some really interesting and quite difficult analytical questions coming out of that. One of the most interesting analytical questions arising from all of that is whether or not you can take into account the end of the pandemic when you're doing evaluation. This is an issue more widely for valuation, but sounds particularly in the business rates context. There are some cases in business rates which suggest that you have to take the material day factors as frozen in time when you're carrying out your valuation. So the classic case on this is called Williams against Scottish and Newcastle, where you had a pub which was, it was a pub with planning permission for use as a shop. Its open market rental value as a shop would have been something like 10 times greater than what it was worth as a pub. And the cost of converting it from a pub to a shop would have been equivalent to about 3 months' rent. In other words, in the real world, there's absolutely no doubt that the tenant taking the property would have turned it into a shop, or would have taken it to use as a shop. There's no way it was going to let as a pub. But for business rates purposes, its mode or category of occupation, which is a material day factor, was a pub on the relevant date, and it couldn't be assumed to change. Now, whether or not that's going to be true of things like the coronavirus regulations in business rates, it is going to be a very value significant question, because if you can assume that the factor is capable of change, if you can assume when you're working out the tenant's bid that the pandemic's going to end and the regulations will be repealed, that gives quite a starkly different answer to if you have to assume that they're not going to end. So there are going to be some really interesting and difficult questions thrown up in business rates in that regard. Now I can see that Aaron's back. So what I'll do is I'll hand back over to Aaron to finish off his talk, and you won't hear from me again at the end now because I've done the bit I was going to do at the end. So back to you, Aaron. Hopefully you're back and stable now.
Thank you very much. I have absolutely no idea what happened there. All of a sudden, I was talking to a blank screen. But those are the technological challenges that we face. Thanks very much, Luke, for having the wit to step back in and piece and work around me. Now, I think what I was saying was that I didn't think, in my personal view, that this concept of a nominal value could actually be applied to an asset. The only circumstances where I do think that a nominal value could be applied is when there was actual evidence of it, such as a comparable of a similar property receiving only nominal offers, which were eventually accepted as rent by the landlord, because they came to the conclusion that there were no further ways of doing it. So against that background, and having considered the challenges in terms of valuation that exist, what are the answers? Well, can I just have control of the screen again, please? Thank you. Where does that leave us? Well, the first and most obvious solution, perhaps, is agree the rent. If you can agree the rental value, then you remove any risk of court adopting a valuation methodology that hurts your client. Of course, it goes without saying that if we could all just agree rents, then there would be very little need for any of us to litigate any of these points in the first place. The second possible solution is to agree or determine a low rent, but allow within the lease for an upward-only rent review after a short period, such as a year, to allow the uncertainty to ease. There are, of course, a number of problems with this approach. First, if there is no rent review mechanism in the lease, then one will have to be agreed or inserted by the court if the tenant won't, or the landlord won't agree to that rent review provision being put in. Because previously we were talking about disputes where all the terms were settled, save for the rent. But this adds another complexity to the litigation in that you're trying to alter the terms of the lease and add a rent review provision. Secondly, and perhaps the most obvious problem with this, is that you could well simply just be putting the problem off until next year. And next year there may still not be any comparable evidence or steadiness in the market to allow you to actually deal with the issue that arose now. So I can't really see that it's that compelling to agree a lower rent with an upward only rent review, because you are just effectively putting off the problem until next time. The next solution is to grant only a short tenancy or a tenancy with a break that can be exercised very shortly. Now, again, there are problems with this. Much more risk for the tenants in a situation like this. If the landlord is considering taking the property back, or if the landlord has any views of selling the portfolio or anything like that, then the tenant may not want to give the landlord an opportunity to get back into the property, which obviously having a short tenancy or a tenancy with a short break will introduce. Obviously, in our hypothetical at the moment, we've agreed as landlord to a new tenancy being granted, but our position may well change in a year, especially if we're allowed to look at the market conditions and take a view, well, actually it might be best if we bring this tenancy to an end and get in a new tenant or redevelop. The second issue with this is that the tenant may want to rely on uncertain or lower rents at the moment, and may want to actually press for a longer tenancy because they will say, well, the market evidence suggests that the market is nosediving, therefore rent should be lower, and therefore we want you to be bound as landlord by a rent that is lower for X amount of time, and therefore we're not prepared to accept or agree a shorter term. The third, so the next way of potentially dealing with this is to agree some other basis of rent other than the size and location of property, such as turnover rent. There's been a lot in the press recently with high street retailers seeking to push landlords towards retail rent. And certainly my experience is that most landlords are resisting it quite vociferously. This is because it's a radical wholesale change that may cause landlords difficulty from an asset valuation point of view. Most landlords value their assets based on the rent that they receive from it, and therefore they need certainty to know what rent they will get year on year. The second reason that this seems to me to be an unworkable solution is issues with assignment and with what happens if another tenant comes in. You could potentially have a situation where, in the case of our restaurant, one particular restaurateur, the new big thing of the time, may have the potential of having a far higher turnover than the current tenant, and therefore obviously there would be an incentive for the landlord to want to assign to a new tenant or want to get rid of the current tenant. Again, all of these things lead to uncertainty, and I think that the choosing another basis of rent other than size and location ultimately, while it may be favoured by some particularly high street tenants, isn't going to be the way forward. So the most likely outcome, in my view, is a rent-free period to reflect the pandemic, followed by a rent set to pre-pandemic comparables. In other words, the pandemic is just seen as a blip that is capitalised as a rent-free period to reflect the fact that property either can't trade or can trade but has limitations on how it can trade, or is trading but has a lower footfall, for example. But the headline rent is set by reference to pre-pandemic comparables. Now, the advantage of this is, number one, there is certainty as to what the rent is for both the landlord and the tenant. Number two, it's based on sound valuation principles. It's based on looking at a willing landlord and a willing tenant, having a basket of comparables from pre-pandemic times, and coming up with what the market rent of that property would be but for the pandemic, and then allowing for a calculation to take place, which would be a matter of judgment for expert valuers, as to how long there should be a discounted period. Now, most experienced valuers know that they can factor in a fitting out period or a rent-free period or other types of periods that have a reduced rent as a result of a certain event. And in my view, that shouldn't be too difficult for experienced valuers to do in these circumstances. And the third, and perhaps the most compelling reason, is that both the landlord and the tenant share the risk if this principle is adopted. The rent-free period is capitalised over the life of the lease. So for a 5-year lease with a 6-month rent-free period, for example, that is stretched over the length of the lease and reduces the overall rent that is paid over those 5 years. So the landlord does actually receive a reduced rent, which there may be a risk if the market picks straight back up after lockdown eases, if a vaccine is come up with or something like that. Whereas the tenant also shares the risk if the opposite occurs and if there's a second lockdown, for example. And after all, that is what the relationship of landlord and tenant is, and that's what good negotiation of terms in leases is. It's about sharing risk. So those are my views on what the issues are at the moment, given the current pandemic. My view on what the case law suggests should be the appropriate rationale and thinking, and my view, a worked example of what the most likely outcome is. I do take a step back, however, and say, to my knowledge, there have not been any finished cases on 54 Act renewals that have taken place during lockdown, certainly no reported ones. Many people are trying to adjourn them. Many courts are not being sympathetic to that. And many people, certainly many more people, are simply negotiating and coming up with agreed solutions rather than allow the uncertainty of getting this matter through court. Thank you all very much for bearing with my slight technical issues. I will now, if I may, hand back to Luke. I think we're going to take some questions.
Thanks very much, Aaron. That's right. I don't think there's anything in the remaining slides that that I didn't cover during Aaron's brief hiatus, so we don't need to go back to them. Like Aaron, I'm not aware of any 54 Act cases to have considered any issues like this. The closest precedent that I can think of is a business rates case called Repavlu, which was all about the valuation of a property on Paternoster Square during the period of the Occupy London protests, when the police had put all kinds of movement restrictions on the area for a temporary period of time. And it will be a comfort to know that the upper tribunal's conclusion on how to value that property followed essentially the line which Aaron has set out as what he thinks it to be the most likely outcome. So in as far as we have any precedents which are relevant, they follow essentially what we've just heard. Now, if there are any questions, I'd invite you please just to pop them in the chat function. I'm conscious of the time, and I'm conscious that we don't have any as of yet. So if you have any burning questions, do pop them up now. Otherwise, what I think I will do is draw proceedings to a close in just a moment. And if there are any questions, do let us know after the session's finished, and Aaron and I will do our best to answer them offline when we're less likely to be cursed any further by the Zoom gods, and we'll take it in that way. I'm not seeing any questions coming up, and it's now 5 o'clock on the dot. So all that remains, I think, is for me to say thank you very much to all of you for attending. Apologies once again for our technological difficulties, but I hope you're able to get the bulk of the session from us. And do get in touch if you have any further questions. Have a good afternoon, everyone. Thank you very much.
Thank you very much.